Hello, everyone. Today we're going to continue with part two of the Dobbs v. Jackson opinion. We're getting into the concurrences and dissents. So, Justice Thomas, concurring. I join the opinion of the court because it correctly holds that there is no constitutional right to abortion. Respondents evoke one source for that right. The 14th Amendment's guarantee that no state shall deprive any person of life, liberty, or property without due process of law. The court well explains why, under our substantive due process precedents, the purported right to abortion is not a form of liberty protected by the Due Process Clause. Such a right is neither deeply rooted in this nation's history and tradition, nor implicit in the concept of ordered liberty. The idea that the framers of the 14th Amendment understood the Due Process Clause to protect a right to abortion is farcical. Quoting June Medical Services LLC versus Russo, Justice Thomas dissenting. I write separately to emphasize a second, more fundamental reason why there is no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates that due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. Other sources, by contrast, suggest that due process of law prohibited legislatures from authorizing the deprivation of a person's life, liberty, or property without providing him the customary procedures to which free men were entitled by the old law of England. Either way, the Due Process Clause at most guarantees process. It does not, as the court's substantive due process cases suppose, forbid the government to infringe certain fundamental liberty interests at all, no matter what process isn't provided. As I have previously explained, substantive due process is an oxymoron that lacks any basis in the Constitution. The notion that a constitutional provision that guarantees only process before a person is deprived of life, liberty, or property could define the substance of those rights strains credulity for even the most casual user of words. The resolution of this case is thus straightforward. Because the Due Process Clause does not secure any substantive rights, it does not secure a right to abortion. The court today declines to disturb substantive due process jurisprudence generally or the doctrine's application in other specific contexts. Cases like Griswold v. Connecticut, right of married persons to obtain contraceptives, Lawrence v. Texas, right to engage in private consensual sexual acts, and Obergefell v. Hodges, right to same-sex marriage, are not at issue. The court's abortion cases are unique, and no party has asked us to decide whether our entire 14th Amendment jurisprudence must be preserved or revised. Thus, I agree that nothing in the court's opinion should be understood to cast doubt on precedents that do not concern abortion. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Because any substantive due process decision is demonstrably erroneous, we have a duty to correct the error established in those precedents. After overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States, protected by the 14th Amendment. To answer that question, we would need to decide important antecedent questions, including whether the Privileges or Immunities Clause protects any rights that are not enumerated in the Constitution, and if so, how to identify those rights. That said, even if the clause does protect unenumerated rights, the court conclusively demonstrates that abortion is not one of them under any plausible interpretive approach. Moreover, apart from being a demonstrably incorrect reading of the Due Process Clause, the legal fiction of substantive due process is particularly dangerous. At least three dangers favor jettisoning the doctrine entirely. First, substantive due process exalts judges at the expense of the people from whom they derive their authority. Because the Due Process Clause speaks only to process, the court has long struggled to define what substantive rights it protects. In practice, the court's approach for identifying those fundamental rights unquestionably involves policymaking rather than neutral legal analysis. The court defines new rights in line with its own extra-constitutional value preferences and nullifies state laws that do not align with the judicially created guarantees. Nowhere is this exaltation of judicial policymaking clearer than this court's abortion jurisprudence. In Roe v. Wade, the court divined a right to abortion because it felt that the 14th Amendment's concept of personal liberty included a right of privacy that is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. In Planned Parenthood of Southeastern Pennsylvania versus Casey, the court likewise identified an abortion guarantee in the liberty protected by the 14th Amendment. The court likewise identified an abortion guarantee in the liberty protected by the 14th Amendment. But rather than a right of privacy, it invoked an ethereal right to define one's own concept of existence, of meaning, of the universe, and of the mysteries of human life. As the court's preferred manifestation of liberty changed, so too did the test used to protect it, as Roe's author lamented. Chief Justice Blackmun concurring and dissenting in part, the Roe framework is far more administrable and far less manipulable than the undue burden standard. Now, in this case, the nature of the purported liberties supporting the abortion right has shifted yet again. Respondents in the United States propose no fewer than 3 different interests that supposedly spring from the Due Process Clause. They include bodily integrity, personal autonomy in matters of family, medical care, and faith, and woman's equal citizenship. That 50 years have passed since Roe, and abortion advocates still cannot coherently articulate the right or rights at stake proves the obvious. The right to abortion is ultimately a policy goal in desperate search of a constitutional justification. Second, substantive due process distorts other areas of constitutional law. For example, once this court identifies a fundamental right for one class of individuals, it invokes the Equal Protection Clause to demand exacting scrutiny of statutes that deny the right to others. See, for example, Eisenstadt v. Baird, relying on Griswold to invalidate a state statute prohibiting distribution of contraceptives to unmarried persons. Statutory classifications implicating certain non-fundamental rights, meanwhile, receive only cursory review. Similarly, this court deems unconstitutionally vague or overbroad those laws that impinge on its preferred rights while letting slide those laws that implicate supposedly lesser values. In fact, our vagueness doctrine served as the basis for the first draft of the majority opinion in Roe v. Wade, and it since has been deployed to nullify even mild regulations of the abortion industry. Therefore, regardless of the doctrinal context, the court often demands extra justifications for encroachments on preferred rights while relaxing purportedly higher standards of review for less preferred rights. Substantive due process is the core inspiration for many of the court's constitutionally unmoored policy judgments. Third, substantive due process is often wielded to disastrous ends. For instance, in Dred Scott v. Sanford, the court invoked a species of substantive due process to announce that Congress was powerless to emancipate slaves brought into the federal territories. While Dred Scott was overruled on the battlefields of the Civil War and by constitutional amendments after Appomattox, that overruling was purchased at the price of immeasurable human suffering. Now today, the court rightly overrules Roe and Casey, 2 of this court's most notoriously incorrect substantive due process decisions. After more than 63 million abortions have been performed, after more than 63 million abortions have been performed, the harm caused by this court forays into substantive due process. The harm caused by this court's forays into substantive due process remains immeasurable. Because the court properly applies our substantive due process precedents to reject the fabrication of a constitutional right to abortion, and because this case does not present the opportunity to reject substantive due process entirely, I join the court's opinion. But in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. Justice Kavanaugh concurring. I write separately to explain my additional views about why Roe was wrongly decided, why Roe should be overruled at this time, and the future implications of today's decision. Abortion is a profoundly difficult and contentious issue because it presents an irreconcilable conflict between the interest of a pregnant woman who seeks an abortion and the interest in protecting fetal life. The interests on both sides of the abortion issue are extraordinarily weighty. On the one side, many pro-choice advocates forcefully argue that the ability to obtain an abortion is critically important for women's personal and professional lives and for women's health. They contend that the widespread availability of abortion has been essential for women to advance in society and to achieve greater equality over the last 50 years. And they maintain that women must have the freedom to choose for themselves whether to have an abortion. On the other side, many pro-life advocates forcefully argue that a fetus is a human life. They contend that all human life should be protected as a matter of human dignity and fundamental morality. And they stress that a significant percentage of Americans with pro-life views are women. When it comes to abortion, one interest must prevail over the other at any given point in a pregnancy. Many Americans of good faith would prioritize the interests of the pregnant woman. Many other Americans of good faith instead would prioritize the interest in protecting fetal life, at least unless, for example, an abortion is necessary to save the life of the mother. Of course, many Americans are conflicted or have nuanced views that may vary depending on the particular time in pregnancy or the particular circumstances of a pregnancy. The issue before this court, however, is not the policy or morality of abortion. The issue before this court is what the Constitution says about abortion. The Constitution does not take sides on the issue of abortion. The text of the Constitution does not refer to or encompass abortion. To be sure, this court has held that the Constitution protects unenumerated rights that are deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. But a right to abortion is not deeply rooted in American history and tradition, as the court today thoroughly explains. On the question of abortion, the Constitution is therefore neither pro-life nor pro-choice. The Constitution is neutral and leaves the issue for the people and their elected representatives to resolve through the democratic process in the states or Congress, like the numerous other difficult questions of American social and economic policy that the Constitution does not address. Because the Constitution is neutral on the issue of abortion, this court must also be scrupulously neutral. The 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either a pro-life or a pro-choice abortion policy for all 330 million people in the United States. Instead of adhering to the Constitution's neutrality, the court in Roe took sides on the issue and unilaterally decreed that abortion was legal throughout the United States up to the point of viability, about 24 weeks of pregnancy. The court's decision today properly returns the court to a position of neutrality and restores the people's authority to address the issue of abortion through the processes of democratic self-government established by the Constitution. Some amicus briefs argue that the court today should not only overrule Roe and return to a position of judicial neutrality on abortion, but should go further and hold that the Constitution outlaws abortion throughout the United States. No justice of this court has ever advanced that position. I respect those who advocate for that position, just as I respect those who argue that this court should hold that the Constitution legalizes pre-viability abortion throughout the United States. But both positions are wrong as a constitutional matter, in my view. The Constitution neither outlaws abortion nor legalizes abortion. To be clear then, the court's decision today does not outlaw abortion throughout the United States. On the contrary, the court's decision properly leaves the question of abortion for the people and their elected representatives in the democratic process. Through that democratic process, the people and their representatives may decide to allow or limit abortion. As Justice Scalia stated, the states may, if they wish, permit abortion on demand, but the Constitution does not require them to do so. Today's decision, therefore, does not prevent the numerous states that readily allow abortion from continuing to readily allow abortion. That includes, if they choose, the amici states supporting the plaintiff in this court: New York, California, Illinois, Maine, Massachusetts, Rhode Island, Vermont, Connecticut, New Jersey, Pennsylvania, Delaware, Maryland, Michigan, Wisconsin, Minnesota, New Mexico, Colorado, Nevada, Oregon, Washington, and Hawaii. By contrast, other states may maintain laws that more strictly limit abortion. After today's decision, all of the states may evaluate the competing interests and decide how to address this consequential issue. In arguing for a constitutional right to abortion that would override the people's choice in the democratic process, the plaintiff Jackson Women's Health Organization and its amici emphasize that the Constitution does not freeze the American people's rights as of 1791 or 1868. I fully agree. To begin, I agree that constitutional rights apply to situations that were unforeseen in 1791 or 1868. such as applying the First Amendment to the Internet or the Fourth Amendment to cars. Moreover, the Constitution authorizes the creation of new rights, state and federal, statutory and constitutional. But when it comes to creating new rights, the Constitution directs the people to the various processes of democratic self-government contemplated by the Constitution, state legislation, state constitutional amendments, federal legislation, and federal constitutional amendments. The Constitution does not grant the 9 unelected members of this court the unilateral authority to rewrite the Constitution to create new rights and liberties based on our own moral or policy views. As Justice Rehnquist stated, this court has not been granted a roving commission either by the Founding Fathers or by the framers of the 14th Amendment to strike down laws that are based upon notions of policy or morality suddenly found unacceptable by a majority of this court. The court, therefore, does not possess the authority either to declare a constitutional right to abortion or to declare a constitutional prohibition of abortion. In sum, the Constitution is neutral on the issue of abortion and allows the people and their elected representatives to address the issue through the democratic process. In my respectful view, the court in Roe therefore erred by taking sides on the issue of abortion. The more difficult question in this case is stare decisis, that is, whether to overrule the Roe decision. The principle of stare decisis requires respect for the court's precedents and for the accumulated wisdom of the judges who have previously addressed the same issue. Stare decisis is rooted in Article 3 of the Constitution and is fundamental to the American judicial system and to the stability of American law. Adherence to precedent is the norm, and stare decisis imposes a high bar before this court may overrule a precedent. This court's history shows, however, that stare decisis is not absolute and indeed cannot be absolute. Otherwise, as the court today explains, many long since overruled cases such as Plessy v. Ferguson, Lochner v. New York, Minersville School District versus Gobbets, and Bowers v. Hardwick would never have been overruled and would still be the law. In his canonical Burnett opinion in 1932, Justice Brandeis stated that in cases involving the federal Constitution, where correction through legislative action is practically impossible, this court has often overruled its earlier decisions. That description of the court's practice remains accurate today. Every current member of this court has voted to overrule precedent. And over the last 100 years, beginning with Chief Justice Taft's appointment in 1921, every one of the 48 justices appointed to this court has voted to overrule precedent. Many of those justices have voted to overrule a substantial number of very significant and long-standing precedents. See, for example, Obergefell v. Hodges, overruling Baker v. Nelson, Brown v. Board of Education, overruling Plessy v. Ferguson, West Coast Hotel Company v. Parrish, overruling Adkins v. Children's Hospital of D.C., and in effect, Lochner v. New York. But that history alone does not answer the critical question, when precisely should the court overrule an erroneous constitutional precedent? The history of stare decisis in this court establishes that a constitutional precedent may be overruled only when 1. The prior decision is not just wrong, but is egregiously wrong. 2. The prior decision has caused significant negative jurisprudential or real-world consequences. And 3. Overruling the prior decisions would not unduly upset legitimate reliance interests. Applying those factors, I agree with the court today that Roe should be overruled. The court in Roe erroneously assigned itself the authority to decide a critically important moral and policy issue that the Constitution does not grant this court the authority to decide. As Justice Byron White succinctly explained, Roe was an improvident and extravagant exercise of the power of judicial review, because nothing in the language or history of the Constitution supports a constitutional right to abortion. Of course, the fact that a precedent is wrong, even egregiously wrong, does not alone mean that the precedent should be overruled. But as the court today explains, Roe has caused significant negative jurisprudential and real-world consequences. By taking sides on a difficult and contentious issue on which the Constitution is neutral, Roe overreached and exceeded this court's constitutional authority, gravely distorted the nation's understanding of this court's proper constitutional role, and caused significant harm to what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. All of that explains why tens of millions of Americans and the 26 states that explicitly asked the court to overrule Roe do not accept Roe even 49 years later. Under the court's long-standing stare decisis principles, Roe should be overruled. But the stare decisis analysis here is somewhat more complicated because of Casey. In 1992, 19 years after Roe, Casey acknowledged the continuing dispute over Roe. The court sought to find common ground that would resolve the abortion debate and end the national controversy. After careful and thoughtful consideration, the Casey plurality reaffirmed a right to abortion through viability, about 24 weeks, while also allowing somewhat more regulation of abortion than Roe had allowed. I have deep and unyielding respect for the justices who wrote the Casey plurality opinion, and I respect the Casey plurality's good faith effort to locate some middle ground or compromise that could resolve this controversy for America. But as has become increasingly evident over time, Casey's well-intentioned effort did not resolve the abortion debate. The national division has not ended. In recent years, a significant number of states have enacted abortion restrictions that directly conflict with Roe. Those laws cannot be dismissed as political stunts or as outlier laws. Those numerous state laws collectively represent the sincere and deeply held views of tens of millions of Americans who continue to fervently believe that allowing abortion up to 24 weeks is far too radical and far too extreme, and does not sufficiently account for what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. In this case, moreover, a majority of the states, 26 in all, asked the court to overrule Roe and return the abortion issue to the states. In short, Casey's stare decisis analysis rested in part on the predictive judgment about the future development of state laws and of the people's views on the abortion issue. But that predictive judgment has not borne out. As the court today explains, the experience over the last 30 years conflicts with Casey's predictive judgment and therefore undermines Casey's precedential force. In any event, although Casey is relevant to the stare decisis analysis, the question of whether to overrule Roe cannot be dictated by Casey alone. To illustrate that stare decisis point, consider an example. Suppose that in 1924 this court had expressly reaffirmed Plessy v. Ferguson and upheld the state's authority to segregate people based on the basis of race. Would the court in Brown some 30 years later in 1954 have reaffirmed Plessy and upheld racially segregated schools simply because of that intervening 1924 precedent? Surely the answer is no. In sum, I agree with the court's application today of the principles of stare decisis and its conclusion that Roe should be overruled. After today's decision, the 9 members of this court will no longer decide the basic legality of pre-viability abortion for all 330 million Americans. That issue will be resolved by the people and their representatives in the democratic process in the states or Congress. But the party's arguments have raised other related questions, and I address some of them here. First is the question of how this decision will affect other precedents involving issues such as contraception and marriage, in particular the decisions in Griswold v. Connecticut, Eisenstadt v. Baird, Loving v. Virginia, and Obergefell v. Hodges. I emphasize what the court today states. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. Second, as I see it, some of the other abortion-related legal questions raised by today's decision are not especially difficult as a constitutional matter. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. May a state retroactively impose liability or punishment for an abortion that occurred before today's decision takes effect? In my view, the answer is no, based on the Due Process Clause or the Ex Post Facto Clause. Other abortion-related legal questions may emerge in the future, but this court will no longer decide the fundamental question of whether abortion must be allowed throughout the United States through 6 weeks or 12 weeks or 15 weeks or 24 weeks or some other line. The court will no longer decide how to evaluate the interests of the pregnant woman and the interests in protecting fetal life throughout pregnancy. Instead, those difficult moral and policy questions will be decided, as the Constitution dictates, by the people and their elected representatives through the constitutional processes of democratic self-government. The Roe Court took sides on a consequential moral and policy issue that this court had no constitutional authority to decide. By taking sides, the Roe Court distorted the nation's understanding of this court's proper role in the American constitutional system, and thereby damaged the court as an institution. As Justice Scalia explained, Roe destroyed the compromises of the past, rendered compromise impossible for the future, and required the entire issue to be resolved uniformly at the national level. The court's decision today properly returns the court to a position of judicial neutrality on the issue of abortion, and properly restores the people's authority to resolve the issue of abortion through the processes of democratic self-government established by the Constitution. To be sure, many Americans will disagree with the court's decision today. That would be true no matter how the court decided this case. Both sides on the abortion issue believe sincerely and passionately in the rightness of their cause. Especially in those difficult and fraught circumstances, the court must scrupulously adhere to the Constitution's neutral position on the issue of abortion. Since 1973, more than 20 justices of this court have now grappled with the divisive issue of abortion. I greatly respect all of the justices, past and present, who have done so. Amidst extraordinary controversy and challenges, all of them have addressed the abortion issue in good faith, after careful deliberation and based on their sincere understandings of the Constitution and of precedent. I have endeavored to do the same. In my judgment on the issue of abortion, the Constitution is neither pro-life nor pro-choice. The Constitution is neutral, and this court likewise must be scrupulously neutral. The court today properly heeds the constitutional principle of judicial neutrality and returns the issue of abortion to the people and their elected representatives in the democratic process. Chief Justice Roberts, concurring in the judgment, we granted certiorari to decide one question: whether all pre-viability prohibitions on elective abortions are unconstitutional. That question is directly implicated here. Mississippi's Gestational Age Act generally prohibits abortion after the 15th week of pregnancy, several weeks before a fetus is regarded as viable outside the womb. In urging our review, Mississippi stated that its case was an ideal vehicle to reconsider the bright line viability rule, and that a judgment in its favor would not require the court to overturn Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania v. Casey. Today, the court nonetheless rules for Mississippi by doing just that. I would take a more measured course. I agree with the court that the viability line established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense. Our abortion precedents describe the right at issue as a woman's right to choose to terminate her pregnancy. That right should therefore extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. Certainly not all the way to viability. Mississippi's law allows a woman 3 months to obtain an abortion, well beyond the point at which it is considered late to discover a pregnancy. I see no sound basis for questioning the adequacy of that opportunity. But that is all I would say, out of adherence to a simple yet fundamental principle of judicial restraint. If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. Perhaps we are not always perfect in following that command, and certainly there are cases that warrant an exception. But this is not one of them. Surely we should adhere closely to principles of judicial restraint here, where the broader path the court chooses entails repudiating a constitutional right we have not only previously recognized, but also expressly reaffirmed, applying the doctrine of stare decisis. The court's opinion is thoughtful and thorough, but those virtues cannot compensate for the fact that its dramatic and consequential ruling is unnecessary to decide the case before us. Let me begin with my agreement with the court on the only question we need decide here: whether to retain the rule from Roe and Casey that a woman's right to terminate her pregnancy extends up to the point that the fetus is regarded as viable outside the womb. I agree that this rule should be discarded. First, this court seriously erred in Roe in adopting viability as the earliest point at which a state may legislate to advance its substantial interests in the area of abortion. Roe set forth a rigid three-part framework anchored to viability, which more closely resembled a regulatory code than a body of constitutional law. That framework, moreover, came out of thin air. Neither the Texas statute challenged in Roe nor the Georgia statute at issue in its companion case, Doe v. Bolton, included any gestational age limit. No party or amicus asked the court to adopt a bright-line viability rule, and as for Casey, arguments for or against the viability rule played only a de minimis role in the parties' briefing and in the oral argument. It is thus hardly surprising that neither Roe nor Casey made a persuasive or even colorable argument for why the time for terminating a pregnancy must extend to viability. The court's jurisprudence on this issue is a textbook illustration of the perils of deciding a question neither presented nor briefed. As has been often noted, Roe's defense of the line boiled down to a circular assertion that the state's interest is compelling only when an unborn child can live outside the womb, because that is when the unborn child can live outside the womb. 20 years later, the best defense of the viability line the Casey plurality could conjure up was workability. Although the plurality attempted to add more content by opining that it might be said that a woman who fails to act before viability has consented to the state's intervention on behalf of the developing child. That mere suggestion provides no basis for choosing viability as the critical tipping point. A similar implied consent argument could be made with respect to a law banning abortions after 15 weeks, well beyond the point at which nearly all women are aware that they are pregnant. The dissent, which would retain the viability line, offers no justification for it either. This court's jurisprudence since Casey, moreover, has eroded the underpinnings of the viability line, such as they were. The viability line is a relic of a time when we recognized only two state interests warranting regulation of abortion: maternal health and protection of potential life. That changed with Gonzalez v. Carhart. There, we recognized a broader array of interests, such as drawing a bright line that clearly distinguishes abortion and infanticide, maintaining societal ethics, and preserving the integrity of the medical profession. The viability line has nothing to do with advancing such permissible goals. Consider, for example, statutes passed in a number of jurisdictions that forbid abortions after 20 weeks of pregnancy, premised on the theory that a fetus can feel pain at that stage of development. Assuming that prevention of fetal pain is a legitimate state interest after Gonzalez, there seems to be no reason why viability would be relevant to the permissibility of such laws. The same is true of laws designed to protect the integrity and ethics of the medical profession and restrict procedures likely to coerce society to the dignity of human life. Mississippi's law, for instance, was premised in part on the legislature's finding that the dilation and evacuation procedure is a barbaric practice dangerous for the maternal patient and demeaning to the medical profession. That procedure accounts for most abortions performed after the first trimester, 2 weeks before the period at issue in this case, and involves the use of surgical instruments to crush and tear the unborn child apart. Again, it would make little sense to focus on viability when evaluating a law based on these permissible goals. In short, the viability rule was created outside the ordinary course of litigation, is and always has been completely unreasoned, and it fails to take account of state interests since recognized as legitimate. It is indeed telling that other countries almost uniformly eschew a viability line. Only a handful of countries, among them China and North Korea, permit elective abortions after 20 weeks. The rest have coalesced around a 12-week line. The court rightly rejects the arbitrary viability rule today. None of this, however, requires that we also take the dramatic step of altogether eliminating the abortion right first recognized in Roe. Mississippi itself previously argued as much as this court in its litigation. When the state petitioned for our review, its basic request was straightforward: clarify whether abortion prohibitions before viability are always unconstitutional. The state made a number of strong arguments that the answer is no. Arguments that, as discussed, I find persuasive, and it went out of its way to make clear that it was not asking the court to repudiate entirely the right to choose whether to terminate a pregnancy. To be clear, the questions presented in this petition do not require the court to overturn Roe or Casey. Mississippi tempered that statement with an oblique one-sentence footnote intimating that if the court could not reconcile Roe or Casey with current facts or other cases, it should not retain erroneous precedent. But the state never argued that we should grant review for that purpose. After we granted certiorari, however, Mississippi changed course. In its principal brief, the state bluntly announced that the court should overrule Roe and Casey. The Constitution does not protect a right to an abortion, it argued, and a state should be able to prohibit elective abortions if a rational basis supports doing so. The court now rewards that gambit, noting 3 times that the parties presented no half measures and argued that we must either reaffirm or overrule Roe and Casey. Given those 2 options, the majority picks the latter. This framing is not accurate. In its briefs on the merits, Mississippi in fact argued at length that a decision simply rejecting the viability rule would result in a judgment in its favor. But even if the state had not argued as much, it would not matter. There is no rule that parties can confine this court to disposing of their case on a particular ground, let alone when review was sought and granted on a different one. Our established practice is instead not to formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. Following that fundamental principle of judicial restraint, we should begin with the narrowest basis for disposition, proceeding to consider a broader one only if necessary to resolve the case at hand. It is only where there is no valid narrower ground of decision that we should go on to address a broader issue, such as whether a constitutional decision should be overturned. See Federal Election Commission versus Wisconsin Right to Life, declining to address the claim that a constitutional decision should be overruled when the appellant prevailed on its narrower constitutional argument. Here there is a clear path to deciding this case correctly without overruling Roe, all the way down to the studs. Recognize that the viability line must be discarded, as the majority rightly does, and leave for another day whether to reject any right to an abortion at all. See Webster versus Reproductive Health Services, rejecting Roe's viability line as rigid and indeterminate, while also finding no occasion to revisit the holding of Roe that, under the Constitution, a state must provide an opportunity to choose to terminate a pregnancy. Of course, such an approach would not be available if the rationale of Roe and Casey was inextricably entangled with and dependent upon this viability standard. It is not. Our precedents in this area ground the abortion right in a woman's right to choose. See Carey v. Population Services International, underlying foundation of the holdings in Roe and Griswold v. Connecticut was the right decision in matters of childbearing. And then Marr v. Roe. Roe and other cases recognize a constitutionally protected interest in making certain kinds of important decisions free from governmental compulsion. Roe did not declare an unqualified constitutional right to an abortion, but instead protected the woman from unduly burdensome interference with her freedom to decide whether to terminate her pregnancy. Webster. Roe protects the claims of a woman to decide for herself whether or not to abort a fetus she is carrying. And then Gonzalez, a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy. If that is the basis for Roe, Roe's viability line should be scrutinized from the same perspective, and there is nothing inherent in the right to choose that requires it to extend to viability or any other point, so long as a real choice is provided. See Webster, finding no reason why the state's interest in protecting potential human life should come into existence only at the point of viability. To be sure, in reaffirming the right to an abortion, Casey termed the viability rule Roe's central holding. Other cases of ours have repeated that language, but simply declaring it does not make it so. The question in Roe was whether there was any right to abortion in the Constitution. How far the right extended was a concern that was separate and subsidiary, and not surprisingly, entirely unbriefed. The court in Roe just chose to address both issues in one opinion. It first recognized a right to choose to terminate a pregnancy under the Constitution, and then, having done so, explained that a line should be drawn at viability such that a state could not proscribe abortion before that period. The viability line is a separate rule fleshing out the metes and bounds of Roe's core holding. Applying principles of stare decisis, I would excise that additional rule, and only that rule, from our jurisprudence. The majority lists a number of cases that have stressed the importance of the viability rule to our abortion precedents. I agree that, whether it was originally holding or dictum, the viability line is clearly part of our past precedent, and the court has applied it as such. In several cases since Roe. My point is that Roe adopted two distinct rules of constitutional law. One, that a woman has the right to choose to terminate a pregnancy. Two, that right may be overridden by the state's legitimate interests when the fetus is viable outside the womb. The latter is obviously distinct from the former. I would abandon that timing rule, but see no need to, in this case, to consider the basic right. The court contends that it is impossible to address Roe's conclusion that the Constitution protects a woman's right to abortion without also addressing Roe's rule that the state's interests are not constitutionally adequate to justify a ban on abortion until viability. But we have partially overruled precedents before. For example, United States v. Miller, Daniels v. Williams, and Batson v. Kentucky. and certainly have never held that a distinct holding defining the contours of a constitutional right must be treated as part and parcel of the right itself. Overruling the subsidiary rule is sufficient to resolve this case in Mississippi's favor. The law at issue allows abortions up through 15 weeks, providing an adequate opportunity to exercise the right Roe protects. By the time a pregnant woman has reached that point, her pregnancy is well into the second trimester. Pregnancy tests are now inexpensive and accurate, and a woman ordinarily discovers she is pregnant by 6 weeks of gestation. Almost all know by the end of the first trimester. Safe and effective abortifacients, moreover, are now readily available, particularly during those early stages. Given all this, it is no surprise that the vast majority of abortions happen in the first trimester. Presumably, most of the remainder would also take place earlier if later abortions were not a legal option. Ample evidence thus suggests that a 15-week ban provides sufficient time, absent rare circumstances, for a woman to decide for herself whether to terminate her pregnancy. Whether a precedent should be overruled is a question entirely within the discretion of the court. In my respectful view, the sound exercise of that discretion should have led the court to resolve the case on the narrower grounds set forth above, rather than overruling Roe and Casey entirely. The court says there is no principled basis for this approach, but in fact it is firmly grounded in basic principles of stare decisis and judicial restraint. The court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view those cases. A narrower decision rejecting the misguided viability line would be markedly less unsettling, and nothing more is needed to decide this case. Our cases say that the effect of overruling a precedent on reliance interests is a factor to consider in deciding whether to take such a step, and respondents argue that generations of women have relied on the right to an abortion in organizing their relationships and planning their futures. The court questions whether these concerns are pertinent under our precedents, but the issue would not even arise with a decision rejecting only the viability line. It cannot reasonably be argued that women have shaped their lives in part on the assumption that they would be able to abort up to viability as opposed to 15 weeks. In support of its holding, the court cites 3 seminal constitutional decisions that involved overruling prior precedents: Brown v. Board of Education, West Virginia Board of Education v. Barnett, and West Coast Hotel v. Parrish. The opinion in Brown was unanimous and 11 pages long. This one is neither. Barnett was decided only 3 years after the decision it overruled, 3 justices having had second thoughts. Barnett was decided only 3 years after the decision it overruled, 3 justices having had second thoughts. And West Coast Hotel was issued against a backdrop of unprecedented economic despair that focused attention on the fundamental flaws of existing precedent. It also was part of a sea change in this court's interpretation of the Constitution, signaling the demise of an entire line of important precedents, a feature the court expressly disclaims in today's decision. None of these leading cases, in short, provides a template for what the court does today. The court says we should consider whether to overrule Roe and Casey now, because if we delay, we would be forced to consider the issue again in short order. There would be turmoil until we did so, according to the court, because of existing state laws with shorter deadlines or no deadline at all. But under the narrower approach proposed here, state laws outlawing abortion altogether would still violate binding precedent, and to the extent states have laws that set the cutoff date earlier than 15 weeks, any litigation over that time frame would proceed free from the distorting effect that the viability rule has had on our constitutional debate. The same could be true, for that matter, with respect to legislative consideration in the states. We would then be free to exercise our discretion in deciding whether and when to take up the issue from a more informed perspective. Both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share. I am not sure, for example, that a ban on terminating a pregnancy from the moment of conception must be treated the same under the Constitution as a ban after 15 weeks. A thoughtful member of this court once counseled that the difficulty of a question admonishes us to observe the wise limitations on our function and to confine ourselves to deciding only what is necessary to the disposition of the immediate case. I would decide the question we granted review to answer whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question is no, and there is no need to go further to decide this case. I therefore concur only in judgment. Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting. For half a century, Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania versus Casey have protected the liberty and equality of women. Roe held, and Casey reaffirmed, that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held, and Casey reaffirmed, that in the first stages of pregnancy, the government could not make that choice for women. The government could not control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. Respecting a woman as an autonomous being and granting her full equality meant giving her substantive choice over this most personal and most consequential of all life's decisions. Roe and Casey well understood the difficulty and divisiveness of the abortion issue. The court knew that Americans hold profoundly different views about the morality of terminating a pregnancy, even in its earliest stage. And the court recognized that the state has legitimate interests from the outset of the pregnancy in protecting the life of the fetus that may become a child. So the court struck a balance, as it often does when values and goals compete. It held that the state could prohibit abortions after fetal viability, so long as the ban contained exceptions to safeguard a woman's life or health. It held that even before viability, the state could regulate the abortion procedure in multiple and meaningful ways. But until the viability line was crossed, the court held a state could not impose a substantial obstacle on a woman's right to elect the procedure as she, not the government, thought proper, in light of all the circumstances and complexities of her own life. Today, the court discards that balance. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. An abortion restriction, the majority holds, is permissible whenever rational, the lowest level of scrutiny known to the law. And because, as the court has often stated, protecting fetal life is rational, states will feel free to enact all manner of restrictions. The Mississippi law at issue here bars abortions after the 15th week of pregnancy. Under the majority's ruling, though, another state's law could do so after 10 weeks, or 5, or 3, or 1, or again, from the moment of fertilization. States have already passed such laws in anticipation of today's ruling. More will follow. Some states have enacted laws extending to all forms of abortion procedure, including taking medication in one's own home. They have passed laws without any exceptions for when the woman is the victim of rape or incest. Under those laws, a woman will have to bear her rapist's child or a young girl her father's, no matter if doing so will destroy her life. So too, after today's ruling, some states may compel women to carry to term a fetus with severe physical anomalies. For example, one afflicted with Tay-Sachs disease, sure to die within a few years of birth. States may even argue that a prohibition on abortion need make no provision for protecting a woman from risk of death or physical harm. Across a vast array of circumstances, a state will be able to impose its moral choice on a woman and coerce her to give birth to a child. Enforcement of all these draconian restrictions will also be left largely to the state's devices. A state can, of course, impose criminal penalties on abortion providers, including lengthy prison sentences. But some states will not stop there. Perhaps in the wake of today's decision, a state law will criminalize the woman's conduct too, incarcerating or fining her for daring to seek or obtain an abortion. And as Texas has recently shown, a state can turn neighbor against neighbor, enlisting fellow citizens in the effort to root out anyone who tries to get an abortion or to assist another in doing so. The majority tries to hide the geographically expansive effects of its holding. Today's decision, the majority says, permits each state to address abortion as it pleases. That is cold comfort, of course, for the poor woman who cannot get the money to fly to a distant state for a procedure. Above all others, women lacking financial resources will suffer from today's decision. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provision of information or funding to help women gain access to other states' abortion services. Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again from the moment of conception and without exceptions for rape or incest. If that happens, the views of an individual state's citizens will not matter. The challenge for a woman will be to finance a trip not to New York or California, but to Toronto. Whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. Yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could, within reasonable limits, make her own decision about whether to bear a child, with all the life-transforming consequences that act involves. And in thus safeguarding each woman's reproductive freedom, the Constitution also protects the ability of women to participate equally in this nation's economic and social life. But no longer. As of today, this court holds, a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may be a nightmare. Some women, especially women of means, will find ways around the state's assertion of power. Others, those without money or childcare or the ability to take time off from work, will not be so fortunate. Maybe they will try an unsafe method of abortion and come to physical harm, or even die. Maybe they will undergo pregnancy and have a child, but at significant personal or familial cost. At the least, they will incur the cost of losing control of their lives. The Constitution will, today's majority holds, provide no shield despite its guarantees of liberty and equality for all, and no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception. In turn, those rights led, more recently, to rights of same-sex intimacy and marriage. They are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. The majority, or to be more accurate, most of it, is eager to tell us today that nothing it does casts doubt on precedents that do not concern abortion. But how could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not deeply rooted in history. Not until Roe, the majority argues, did people think abortion fell within the Constitution's guarantee of liberty. The same could be said, though, of most of the rights the majority claims it is not tampering with. The majority could write just as long an opinion showing, for example, that until the mid-20th century, there was no support in American law for a constitutional right to obtain contraceptives. So one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. One piece of evidence on that score seems especially salient: the majority's cavalier approach to overturning this court's precedents. Stare decisis is the Latin phrase for a foundation stone of the rule of law. That things decided should stay decided unless there is a very good reason for change. It is a doctrine of judicial modesty and humility. Those qualities are not evident in today's opinion. The majority has no good reason for the upheaval in law and society it sets off. Roe and Casey have been the law of the land for decades, shaping women's expectations of their choices when an unplanned pregnancy occurs. Women have relied on the availability of abortion both in structuring their relationships and in planning their lives. The legal framework Roe and Casey developed to balance the competing interests in this sphere has proved workable in courts across the country. No recent developments, in either law or fact, have eroded or cast doubt on those precedents. Nothing, in short, has changed. Indeed, the court in Casey already found all of that to be true. Casey is a precedent about precedent. It reviewed the same arguments made here in support of overruling Roe, and it found that doing so was not warranted. The court reverses course today for one reason and one reason only, because the composition of this court has changed. Stare decisis, this court has often said, contributes to the actual and perceived integrity of the judicial process by ensuring that decisions are founded in the law rather than in the proclivities of individuals. Today, the proclivities of individuals rule. The court departs from its obligation to faithfully and impartially apply the law. We dissent. We start with Roe and Casey, and with their deep connections to a broad swath of this court's precedents. To hear the majority tell the tale, Roe and Casey are aberrations. They came from nowhere, went nowhere, and so are easy to excise from this nation's constitutional law. That is not true. After describing the decisions themselves, we explain how they are rooted in and themselves led to other rights giving individuals control over their bodies and their most personal and intimate associations. The majority does not wish to talk about these matters for obvious reasons. To do so would both ground Roe and Casey in this court's precedents and reveal the broad implications of today's decision. But the facts will not so handily disappear. Roe and Casey were from the beginning, and are even more now, embedded in core constitutional concepts of individual freedom and of the equal rights of citizens to decide on the shape of their lives. Those legal concepts, one might even say, have gone far toward defining what it means to be an American. For in this nation, we do not believe that a government controlling all private choices is compatible with a free people. So we do not, as the majority insists today, place everything within the reach of majorities and government officials. We believe in a constitution that puts some issues off limits to majority rule. Even in the face of public opposition, we uphold the right of individuals, yes, including women, to make their own choices and chart their own futures, or at least we did once. Some half-century ago, Roe struck down a state law making it a crime to perform an abortion unless its purpose was to save a woman's life. The Roe court knew it was treading on difficult and disputed ground. It understood that different people's experiences, values, and religious training and beliefs led to opposing views about abortion. But by a 7-2 vote, the court held that in the earlier stages of pregnancy, that contested and contestable choice must belong to a woman, in consultation with her family and doctor. The court explained that a long line of precedents founded in the 14th Amendment's concept of personal liberty protected individual decision-making related to marriage, procreation, contraception, family relationships, and child-rearing and education. For the same reasons, the court held the Constitution must protect a woman's decision whether or not to terminate her pregnancy. The court recognized the myriad ways bearing a child can alter the life and future of a woman and other members of her family. A state could not, by adopting one theory of life, override all rights of the pregnant woman. At the same time, though, the court recognized valid interests of the state in regulating the abortion decision. The court noted in particular important interests in protecting potential life, maintaining medical standards, and safeguarding the health of the woman. No absolutist account of the woman's right could wipe away those significant state claims. The court therefore struck a balance, turning on the stage of the pregnancy at which the abortion would occur. The court explained that early on a woman's choice must prevail, but that at some point the state's interest become dominant. It then set some guideposts. In the first trimester of pregnancy, the state could not interfere at all with the decision to terminate a pregnancy. At any time after that point, the state could regulate to protect the pregnant woman's health, such as by insisting that abortion providers and facilities meet safety requirements. And after the fetus's viability, the point when the fetus has the capability of meaningful life outside the mother's womb, the state could ban abortions except when necessary to preserve the woman's life or health. In the 20 years between Roe and Casey, the court expressly reaffirmed Roe on 2 occasions and applied it on many more. Recognizing that arguments against Roe continue to be made, we responded that the doctrine of stare decisis demands respect in a society governed by the rule of law. And we avowed that the vitality of constitutional principles cannot be allowed to yield simply because of disagreement with them. So the court, over and over, enforced the constitutional principles Roe had declared. Then, in Casey, the court considered the matter anew, and again upheld Roe's core precepts. Casey is in significant measure a precedent about the doctrine of precedent, until today one of the court's most important. But we leave for later that aspect of the court's decision. The key thing now is the substantive aspect of the court's considered conclusion that the essential holding of Roe v. Wade should be retained and once again reaffirmed. Central to that conclusion was a full-throated restatement of a woman's right to choose. Like Roe, Casey grounded that right in the 14th Amendment's guarantee of liberty. That guarantee encompasses realms of conduct not specifically referenced in the Constitution. Marriage is mentioned nowhere in that document, yet the court was no doubt correct to protect the freedom to marry against state interference. And the guarantee of liberty encompasses conduct today that was not protected at the time of the 14th Amendment. It is settled now, the court said, though it was not always so, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood, as well as bodily integrity. Especially important is this web of precedents protecting an individual's most personal choices were those guaranteeing the right to contraception. In those cases, the court had recognized the right of the individual to make the vastly consequential decision whether to bear a child. So too, Casey reasoned, the Liberty Clause protects the decision of a woman confronting an unplanned pregnancy. Her decision about abortion was central, in the same way to her capacity to chart her life's course. In reaffirming the right Roe recognized, the court took full account of the diversity of views on abortion and the importance of various competing state interests. Some Americans, the court stated, deem abortion nothing short of an act of violence against innocent human life, and each state has an interest in protection of potential life, as Roe itself had recognized. On the one hand, that interest was not conclusive. The state could not resolve the moral and spiritual questions raised by abortion in such a definitive way that a woman lacks all choices in the matter. It could not force her to bear the pain and physical constraints of carrying a child to full term, when she would have chosen an early abortion. But on the other hand, the state had, as Roe had held, an exceptionally significant interest in disallowing abortions in the later phase of pregnancy, and it had an ever-present interest in ensuring that the woman's choice is informed and in presenting the case for choosing childbirth over abortion. So Casey again struck a balance, differing from Roe's in only incremental ways. It retained Roe's central holding that the state could bar abortion only after viability. The viability line, Casey thought, was more workable than any other in marking the place where the woman's liberty interest gave way to a state's efforts to preserve potential life. At that point, a second life was capable of independent existence. If the woman, even by then, had not acted, she lacked adequate grounds to object to the state's intervention on the developing child's behalf. At the same time, Casey decided, based on 2 decades of experience, that the Roe framework did not give states sufficient ability to regulate abortion prior to viability. In that period, Casey now made clear the state could regulate not only to protect the woman's health, but also to promote prenatal life. In particular, the state could ensure informed choice and could try to promote childbirth. But the state still could not place an undue burden or substantial obstacle in the path of a woman seeking an abortion. Prior to viability, the woman, consistent with the constitutional meaning of liberty, must retain the ultimate control over her destiny and her body. We make one initial point about this analysis in light of the majority's insistence that Roe and Casey, and we in defending them, are dismissive of a state's interest in protecting prenatal life. Nothing could get those decisions more wrong. As just described, Roe and Casey invoked powerful state interests in that protection operative at every stage of the pregnancy and overriding the woman's liberty after viability. The strength of those state interests is exactly why the court allowed greater restrictions on the abortion right than on other rights deriving from the 14th Amendment. But what Roe and Casey also recognized, which today's majority does not, is that a woman's freedom and equality are likewise involved. That fact, the presence of countervailing interests, is what made the abortion question hard, and what necessitated balancing. The majority scoffs at that idea, castigating us for repeatedly praising the balance the 2 cases arrived at with the word balance in scare quotes. To the majority, balance is a dirty word, as moderation is a foreign concept. The majority would allow states to ban abortion from conception onward because it does not think forced childbirth at all implicates a woman's right to equality and freedom. Today's court, that is, does not think there is anything of constitutional significance attached to a woman's control of her body and the path of her life. Roe and Casey thought that one-sided view misguided. In some sense, that is the difference in a nutshell between our precedents and the majority opinion. The constitutional regime we have lived in for the last 50 years recognized competing interests and sought a balance between them. The constitutional regime we enter today erases the woman's interest and recognizes only the states or the federal governments. The majority makes this change based on a single question. Did the reproductive right recognized in Roe and Casey exist in 1868, the year when the 14th Amendment was ratified? The majority says, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy, and no thought that the 14th Amendment provided one. Of course, the majority opinion refers as well to some later and earlier history. On the one side of 1868, it goes as far back as the 13th century. But that turns out to be wheel spinning. First, it is not clear what relevance such early history should have, even to the majority. See New York State Rifle and Pistol Association versus Bruin. Historical evidence that long predates ratification may not illuminate the scope of the right. If the early history obviously supported abortion rights, the majority would no doubt say that only the views of the 14th Amendment's ratifiers are germane. It is better not to go too far back into antiquity, except if olden law survived to become our founders' law. Second, and embarrassingly for the majority, early law in fact does provide some support for abortion rights. Common law authorities did not treat abortion as a crime before quickening, the point when the fetus moved in the womb. And early American law followed the common law rule. So the criminal law of that early time might be taken as roughly consonant with Roe's and Casey's different treatment of early and late abortions, better than to move forward in time. On the other side of 1868, the majority occasionally notes that many states barred abortion up to the time of Roe. That is convenient for the majority, but it is window dressing. As the same majority plus one just informed us, post-ratification adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text, citing New York State Rifle and Pistol Association. Had the pre-Roe liberalization of abortion laws occurred more quickly and more widely in the 20th century, the majority would say, once again, that only the ratifiers' views are germane. The majority's core legal postulate, then, is that we in the 21st century must read the 14th Amendment just as its ratifiers did, and that is indeed what the majority emphasizes over and over again. The most important historical fact is how the states regulated abortion when the 14th Amendment was adopted. If the ratifiers did not understand something as central to freedom, then neither can we. Or said more particularly, if those people did not understand reproductive rights as part of the guarantee of liberty conferred in the 14th Amendment, then those rights do not exist. As an initial matter, note a mistake in the just preceding sentence. We referred there to the people who ratified the 14th Amendment. What rights did those people have in their heads at the time? But of course, people did not ratify the 14th Amendment. Men did. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation. Indeed, the ratifiers, both in 1868 and when the original Constitution was approved in 1788, did not understand women as full members of the community embraced by the phrase, "we the people." In 1868, the first wave of American feminists were explicitly told, of course by men, that it was not their time to seek constitutional protections. Women would not get even the vote for another half century. To be sure, most women in 1868 also had a foreshortened view of their rights. If most men could not then imagine giving women control over their bodies, most women could not imagine having that kind of autonomy. But that takes away nothing from the core point. Those responsible for the original Constitution, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. When the majority says that we must read our foundational charter as viewed at the time of ratification, except that we may also check it against the Dark Ages, it consigns women to second-class citizenship. Casey itself understood this point, as will become clear. It recollected with dismay a decision this court issued just 5 years after the 14th Amendment's ratification, approving a state's decision to deny a law license to a woman and suggesting as well that a woman had no legal status apart from her husband. There was a time, Casey explained, when the Constitution did not protect men and women alike, but times had changed. A woman's place in society had changed, and constitutional law had changed along with it. The relegation of women to inferior status in either the public sphere or the family was no longer consistent with our understanding of the Constitution. Now, the Constitution protects all individuals, male or female, from the abuse of governmental power or unjustified state interference. So how is it that, as Casey said, our Constitution, read now, grants rights to women, though it did not in 1868? How is it that our Constitution subjects discrimination against them to heightened judicial scrutiny? How is it that our Constitution, through the 14th Amendment's Liberty Clause, guarantees access to contraception, also not legally protected in 1868, so that women can decide for themselves whether and when to bear a child? How is it that, until today, that same constitutional clause protected a woman's right in the event contraception failed to end a pregnancy in its earlier stages? The answer is that this court has rejected the majority's pinched view of how to read our Constitution. The founders, we recently wrote, knew they were writing a document designed to apply to ever-changing circumstances over centuries. Or in the words of the great Chief Justice John Marshall, our Constitution is intended to endure for ages to come, and must adapt itself to a future seen dimly, if at all. That is indeed why our Constitution is written as it is. The framers, both in 1788 and 1868, understood the world changes. So they did not define rights by reference to the specific practices existing at the time. Instead, the framers defined rights in general terms to permit future evolution in their scope and meaning. And over the course of our history, this court has taken up the framers' invitation. It has kept true to the framers' principles by applying them in new ways, responsive to new societal understandings and conditions. Nowhere has that approach been more prevalent than in construing the majestic but open-ended words of the 14th Amendment, the guarantees of liberty and equality for all. And nowhere has that approach produced prouder moments for this country and the court. Consider an example Obergefell used a few years ago. The court there confronted a claim based on Washington v. Glucksberg that the 14th Amendment must be defined in the most circumscribed manner with central reference to specific historical practices, exactly the view today's majority follows. And the court specifically rejected that view. In doing so, the court reflected on what the proposed historically circumscribed approach would have meant for interracial marriage. The 14th Amendment's ratifiers did not think it gave black and white people a right to marry each other. To the contrary, contemporaneous practice deemed that act quite as unprotected as abortion. Yet the court in Loving v. Virginia read the 14th Amendment to embrace the Loving's union. If, Obergefell explains, rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, even when they conflict with liberty and equality, as later and more broadly understood. The Constitution does not freeze for all time the original view of what those rights guarantee or how they apply. That does not mean anything goes. The majority wishes people to think there are but two alternatives. 1, accept the original application of the 14th Amendment and no others, or 2, surrender to judges' own ardent views ungrounded in law about the liberty that Americans should enjoy. At least, that idea is what the majority sometimes tries to convey. At other times, the majority, or rather most of it, tries to assure the public that it has no designs on rights, for example, to contraception. That arose only in the back half of the 20th century. In other words, that it is happy to pick and choose in accord with individual preferences. But that is a matter we discuss later. For now, our point is different. It is that applications of liberty and equality can evolve while remaining grounded in constitutional principles, constitutional history, and constitutional precedents. The second Justice Harlan discussed how to strike the right balance when he explained why he would have invalidated a state's ban on contraceptive use. Judges, he said, are not free to roam where unguided speculation might take them. Yet they also must recognize that the constitutional tradition of this country is not captured whole at a single moment. Rather, its meaning gains content from the long sweep of our history and from successive judicial precedents, each looking to the last and each seeking to apply the Constitution's most fundamental commitments to new conditions. That is why Americans, to go back to Obergefell's example, have a right to marry across racial lines. And it is why, to go back to Justice Harlan's case, Americans have a right to use contraceptives so they can choose for themselves whether to have children. All that is what Casey understood. Casey explicitly rejected the present majority's method. The specific practices of states at the time of the adoption of the 14th Amendment, Casey stated, do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. To hold otherwise, as the majority does today, would be inconsistent with our law. Why? Because the court has vindicated the principle over and over that no matter the sentiment in 1868, there is a realm of personal liberty which the government may not enter, especially relating to bodily integrity and family life. Casey described in detail the court's contraception cases. It noted decisions protecting the right to marry, including to someone of another race. Interracial marriage was illegal in most states in the 19th century, but the court was no doubt correct in finding it to be an aspect of liberty protected against state interference. In reviewing decades and decades of constitutional law, Casey could draw but one conclusion. Whatever was true in 1868, it is settled now, as it was when the court heard arguments in Roe v. Wade, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood. And that conclusion still held good. Until the court's intervention here, it was settled at the time of Roe, settled at the time of Casey, and settled yesterday that the Constitution places limits on a state's power to assert control over an individual's body and most personal decision-making. A multitude of decisions supporting that principle led to Roe's recognition and Casey's reaffirmation of the right to choose, and Roe and Casey in turn supported additional protections for intimate and familial relations. The majority has embarrassingly little to say about these precedents. It literally rattles them off in a single paragraph, and it implies that they have nothing to do with each other or with the right to terminate an early pregnancy. But that is flat wrong. See above, asserting that recognizing a relationship among them as addressing aspects of personal autonomy would inelusibly license fundamental rights to illegal drug use and prostitution, but that is flat wrong. The court's precedents about bodily autonomy, sexual and familial relations, and procreation are all interwoven, all part of a fabric of our constitutional law, and because that is so, of our lives, especially women's lives, where they safeguard a right to self-determination. And eliminating that right, we need to say before further describing our precedents, is not taking a neutral position, as Justice Kavanaugh tries to argue. His idea is that neutrality lies in giving the abortion issue to the states, where some can go one way or some another. But would he say that the court is being scrupulously neutral if it allowed New York and California to ban all the guns they want? If the court allowed some states to use unanimous juries and others not, if the court told the states, decide for yourselves whether to put restrictions on church attendance, we could go on, and in fact we will. Suppose Justice Kavanaugh were to say, in line with the majority opinion, that the rights we just listed are more textually or historically grounded than the right to choose. What then of the right of contraception or same-sex marriage? Would it be scrupulously neutral for the court to eliminate those rights too? The point of all these examples is that when it comes to rights, the court does not act neutrally when it leaves everything up to the states. Rather, the court acts neutrally when it protects the rights against all comers. And to apply that point to the case here, when the court when the court decimates a right women have held for 50 years. The court is not being scrupulously neutral. It is instead taking sides against women who wish to exercise the right and for states like Mississippi that want to bar them from doing so. Justice Kavanaugh cannot obscure that point by appropriating the rhetoric of even-handedness. His position is what it is: a brook no compromise refusal to recognize a woman's right to choose from the first day of a pregnancy, and that position, as we will now show, cannot be squared with this court's long-standing view that women indeed have rights, whatever the state of the world in 1868. To make the most personal and consequential decisions about their bodies and their lives. Consider first, then, the line of this court's cases protecting bodily integrity. No right in this court's time-honored view is held more sacred or more carefully guarded than the right of every individual to the possession and control of his own person. Every adult has, citing Union Pacific Railroad Company versus Botsford, and then Cruzen versus Director of Missouri's Department of Health. Every adult has a right to determine what shall be done with his own body. Or to put it more simply, everyone, including women, owns their own bodies. So the court has restricted the power of government to interfere with a person's medical decisions or compel her to undergo medical procedures or treatments. See, for instance, Winston v. Lee, forced surgery; Roshan v. California, forced stomach pumping; Washington v. Harper, forced administration of antipsychotic drugs. Casey recognized the doctrinal affinity between those precedents and Roe, and that doctrinal affinity is born of a factual likeness. There are few greater incursions on a body than forcing a woman to complete a pregnancy and give birth. For every woman, those experiences involve all manner of physical changes, medical treatments, including the possibility of a cesarean section, and medical risk. Just as one example, an American woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. That women happily undergo those burdens and hazards of their own accord does not lessen how far a state impinges on a woman's body when it compels her to bring a pregnancy to term. And for some women, as Roe recognized, abortions are medically necessary to prevent them. The majority does not say, which is itself ominous, whether a state may prevent a woman from obtaining an abortion when she and her doctor have determined it is a needed medical treatment. So too, Roe and Casey fit neatly into a long line of decisions protecting from government intrusion a wealth of private choices about family matters, child rearing, intimate relationships, and procreation. Those cases safeguard particular choices about whom to marry, whom to have sex with, what family members to live with, how to raise children, and crucially, whether and when to have children. In varied cases, the court explained that those choices, the most intimate and personal a person can make, reflect fundamental aspects of personal identity. They define the very attributes of personhood, and they inevitably shape the nature and future course of a person's life, and often the lives of those closest to her. So the court held those choices belong to the individual and not the government. That is the essence of what liberty requires. And liberty may require it. This court has repeatedly said, even when those living in 1868 would not have recognized the claim, because they would not have seen the person making it as a full-fledged member of the community. Throughout our history, the sphere of protected liberty has expanded, bringing in individuals formerly excluded. In that way, the constitutional values of liberty and equality go hand in hand. They do not inhabit the hermetically sealed containers the majority portrays. So before Roe and Casey, the court expanded in successive cases those who could claim the right to marry, though their relationships would have been outside the law's protection in the mid-19th century. C. Loving, interracial couples, Turner v. Safley, prisoners, and Stanley v. Illinois, offering constitutional protections to untraditional family units. And after Roe and Casey, of course, the court continued in that vein, with a critical stop to hold that the 14th Amendment protected same-sex intimacy. The court resolved that the amendment also conferred on same-sex couples the right to marry. In considering that question, the court held, history and tradition, especially as reflected in the course of our precedent, guide and discipline the inquiry. But the sentiments of 1868 alone do not and cannot rule the present. Casey similarly recognized the need to extend the constitutional sphere of liberty to a previously excluded group. The court then understood, as the majority today does not, that the men who ratified the 14th Amendment and wrote the state laws of the time did not view women as full and equal citizens. A woman then, Casey wrote, had no legal existence separate from her husband. Women were seen only as the center of home and family life, without full and independent legal status under the Constitution. But that could not be true any longer. The state could not now insist on the historically dominant vision of the woman's role. And equal citizenship, Casey realized, was inescapably connected to reproductive rights, the ability of women to participate equally in the life of the nation, in all its economic, social, political, and legal aspects, has been facilitated by their ability to control their reproductive lives. Without the ability to decide whether and when to have children, women could not, in the way men took for granted, determine how they would live their lives, and how they would contribute to the society around them. For much that reason, Casey made clear that the precedents Roe most closely tracked were those involving contraception. Over the course of 3 cases, the court had held that a right to use and gain access to contraception was part of the 14th Amendment's guarantee of liberty. See Griswold, Eisenstadt, and Carey v. Population Services International. That clause, we explained, necessarily conferred a right to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Casey saw Roe as of a piece. In critical respects, the abortion decision is of the same character. Reasonable people, the court noted, could also oppose contraception, and indeed they could believe that some forms of contraception similarly implicate a concern with potential life. Yet the views of others could not automatically prevail against a woman's right to control her own body and make her own choice about whether to bear and probably to raise a child. When an unplanned pregnancy is involved because either contraception or abortion is outlawed, the liberty of the woman is at stake in a sense unique to the human condition. No state could undertake to resolve the moral questions raised in such a definitive way as to deprive a woman of all choice. Faced with all these connections between Roe and Casey, and judicial decisions recognizing other constitutional rights, the majority tells everyone not to worry. It can, so it says, neatly extract the right to choose from the constitutional edifice without affecting any associated rights. Think of someone telling you that the Jenga tower simply will not collapse. Today's decision, the majority first says, does not undermine the decisions cited by Roe and Casey, the ones involving marriage, procreation, contraception, and family relationships, in any way. Note that this first assurance does not extend the right recognized after Roe and Casey, and partly based on them, in particular, rights to same-sex intimacy and marriage. On its later tries, though, the majority includes those two. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. That right is unique, the majority asserts, because abortion terminates life or potential life. So the majority depicts today's decision as a restricted railroad ticket, good for this day and train only. Should the audience for these too much repeated protestations be duly satisfied? We think not. The first problem with the majority's accounts comes from Justice Thomas's concurrence, which makes clear he is not with the program. In saying that nothing in today's opinion casts doubt on non-abortion precedents, Justice Thomas explains he means only that they are not at issue in this very case. Citing above, this case does not present the opportunity to reject those precedents, but he lets us know that he lets us know what he wants to do when they are. In future cases, he says, we should reconsider all of this court's substantive due process precedents, including Griswold, Loving, and Obergefell. And when we reconsider them, then we have a duty to overrule these demonstrably erroneous decisions. So at least one justice is planning to use the ticket of today's decision again and again and again. Even placing the concurrence to the side, the assurance in today's opinion still does not work, or at least that is so if the majority is serious about its sole reason for overturning Roe and Casey, the legal status of abortion in the 19th century. Except in the places quoted above, the state interest in protecting fetal life plays no part in the majority's analysis. To the contrary, the majority takes pride in not expressing a view about the status of the fetus. See above, aligning itself with Roe's and Casey's stance of not deciding whether life or potential life is involved. The majority's departure from Roe and Casey rests instead and only on whether a woman's decision to end a pregnancy involves any 14th Amendment liberty interest, against which Roe and Casey balance the state interest in preserving fetal life. According to the majority, no liberty interest is present because, and only because, the law offered no protection to the woman's choice in the 19th century. But here is the rub. The law also did not then, and would not for ages, protect a wealth of other things. It did not protect the rights recognized in Lawrence and Obergefell to same-sex intimacy and marriage. It did not protect the right recognized in Loving to marry across racial lines. It did not protect the right recognized in Griswold to contraceptive use. For that matter, it did not protect the right recognized in Skinner versus Oklahoma, not to be sterilized without consent. So if the majority is right in its legal analysis, all those decisions were wrong, and all those matters properly belong to the states too, whatever the particular state interest involved. And if that is true, it is impossible to understand as a matter of logic and principle how the majority can say that its opinion today does not threaten, does not even undermine any number of other constitutional rights. Nor does it even help just to take the majority at its word. Assume the majority is sincere in saying, for whatever reason, that it will go so far and no further. Scout's honor. Still, the future significance of today's opinion will be decided in the future, and law often has a way of evolving without regard to original intentions, a way of actually following where logic leads rather than tolerating hard-to-explain lines. Rights can expand in that way. Dissenting in Lawrence, Justice Scalia explained why he took no comfort in the court's statement that a decision recognizing the right to same-sex intimacy did not involve same-sex marriage. That could be true, he wrote, only if one entertains the belief that principle and logic have nothing to do with the decisions of this court. Score 1 for the dissent, as a matter of prophecy, and logic and principle are not one-way ratchets. Rights can contract in the same way and for the same reason, because whatever today's majority might say, one thing really does lead to another. We fervently hope that does not happen because of today's decision. We hope that we will not join Justice Scalia in the Book of Prophets, but we cannot understand how anyone can be confident that today's opinion will be the last of its kind. Consider as our last word on this issue contraception. The Constitution, of course, does not mention that word, and there is no historical right to contraception of the kind the majority insists on. To the contrary, the American legal landscape in the decades after the Civil War was littered with bans on the sale of contraceptive devices. So again, there seems to be two choices. If the majority is serious about its historical approach, then Griswold and its progeny are in the line of fire too. Or if it is not serious, then what is the basis of today's decision? If we had to guess, we suspect the prospects of this court approving bans on contraception are low. But once again, the future significance of today's opinion will be decided in the future. At the least, today's opinion will fuel the fight to get contraception and any other issues with a moral dimension out of the 14th Amendment and into state legislatures. Anyway, today's decision, taken on its own, is catastrophic enough. As a matter of constitutional method, the majority's commitment to replicate in 2022 every view about the meaning of liberty held in 1868 has precious little to recommend it. Our law is, in this constitutional sphere, as in most, has for decades upon decades proceeded differently. It has considered fundamental constitutional principles, the whole course of the nation's history and traditions, and the step-by-step evolution of the court's precedents. It is disciplined but not static. It relies on accumulated judgments, not just the sentiments of one long ago generation of men who themselves believed and drafted the Constitution to reflect that the world progresses, and by doing so, it includes those excluded from that olden conversation, rather than perpetuating its bounds. As a matter of constitutional substance, the majority's opinion has all the flaws its method would suggest. Because laws in 1868 deprived women of any control over their bodies, the majority approves states doing so today. Because those laws prevented women from charting the course of their own lives, the majority says states can do the same again. Because in 1868, the government could tell a pregnant woman, even in the first days of her pregnancy, that she could do nothing but bear a child. It can once more impose that command. Today's decision strips women of agency over what even the majority agrees is a contested and contestable moral issue. It forces her to carry out the state's will, whatever the circumstances and whatever the harm it will wreak on her and her family. In the 14th Amendment's terms, it takes away her liberty, even before we get to stare decisis. We dissent. By overruling Roe, Casey, and more than 20 cases reaffirming or applying the constitutional right to abortion, the majority abandons stare decisis, a principle central to the rule of law. Stare decisis means to stand by things decided. Blackstone called it the established rule to abide by former precedents. Stare decisis promotes the even-handed, predictable, and consistent development of legal principles. It maintains a stability that allows people to order their lives under the law. Stare decisis also contributes to the integrity of our constitutional system of government by ensuring that decisions are founded in the law rather than in the proclivities of individuals. As Hamilton wrote, it avoids an arbitrary discretion in the courts. And as Blackstone said before him, it keeps the scale of justice even and steady, and not liable to waver with every new judge's opinion. The glory of our legal system is that it gives preference to precedent rather than jurists. That is why, the story goes, Chief Justice John Marshall donned a plain black robe when he swore the oath of office. That act personified an American tradition. Judges' personal preferences do not make law. Rather, the law speaks through them. That means the court may not overrule a decision, even a constitutional one, without a special justification. Stare decisis is, of course, not an inexorable command. It is sometimes appropriate to overrule an earlier decision. But the court must have a good reason to do so over and above the belief that the precedent was wrongly decided. It is not citing Halliburton Company versus Erica P. John Fund Incorporated. Oh no, it is not alone sufficient that we would decide a case differently now than we did then, citing Kimball versus Marvel Entertainment. The majority today lists some 30 of our cases as overruling precedent, and argues that they support overruling Roe and Casey. But none does, as further described below and in the appendix. In some, the court only partially modified or clarified a precedent, and in the rest, the court relied on one or more of the traditional stare decisis factors in reaching its conclusion. The court found, for example, 1, a change in legal doctrine that undermined or made obsolete the earlier decision, 2, a factual change that had the same effect, or 3, an absence of reliance because the earlier decision was less than a decade old. The majority is wrong when it says that we insist on a test of changed law or fact alone, although that is present in most of the cases. None of those factors apply here. Nothing, and in particular, no significant legal or factual change, supports overturning a half-century of settled law giving women control over their reproductive lives. First, for all the reasons we have given, Roe and Casey were correct in holding that a state could not resolve the debate about abortion in such a definitive way that a woman lacks all choice in the matter. The court protected women's liberty and women's equality in a way comporting with our 14th Amendment precedents. Contrary to the majority's view, the legal status of abortion in the 19th century does not weaken those decisions, and the majority's repeated refrain about usurping state legislatures' power to address a publicly contested question does not help it on the key issue here. To repeat, the point of a right is to shield individual actions and decisions from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. However divisive, a right is not at the people's mercy. In any event, whether or not we agree with a prior precedent is the beginning, not the end, of our analysis, and the remaining principles of stare decisis weigh heavily against overruling Roe and Casey. Casey itself applied those principles in one of this court's most important precedents about precedent. After assessing the traditional stare decisis factors, Casey reached the only conclusion possible, that stare decisis operates powerfully here. It still does. The standards Roe and Casey set out are perfectly workable. No change in either law or fact have eroded the two decisions, and tens of millions of American women have relied and continue to rely on the right to choose. So, under traditional stare decisis principles, the majority has no special justification for the harm it causes, and indeed, the majority comes close to conceding that point. The majority barely mentions any legal or factual changes that have occurred since Roe and Casey. It suggests that the two decisions are hard for courts to implement but cannot prove its case. In the end, the majority says all it must say to override stare decisis is one thing, that it believes Roe and Casey egregiously wrong. That rule could equally spell the end of any precedent with which a bare majority of the present court disagrees. So how does that approach prevent the scale of justice from wavering with every new judge's opinion? It does not. It makes radical change too easy and too fast, based on nothing more than the new views of new judges. The majority has overruled Roe and Casey for one and only one reason, because it has always despised them, and now it has the votes to discard them. The majority thereby substitutes a rule by judges for the rule of law. Contrary to the majority's view, there is nothing unworkable about Casey's undue burden standard. Its primary focus on whether a state has placed a substantial obstacle on a woman seeking an abortion is the sort of inquiry familiar to judges across a variety of contexts. And it has given rise to no more conflict in application than many standards this court and others unhesitatingly apply every day. General standards like the undue burden standard are ubiquitous in the law, and particularly in constitutional adjudication. When called on to give effect to the Constitution's broad principles, this court often crafts flexible standards that can be applied case by case to a myriad of unforeseeable circumstances. C. Dickerson, no court laying down a general rule can possibly foresee the various circumstances in which it must apply. So, for example, the court asks about undue or substantial burdens on speech, on voting, and on interstate commerce. See, for example, Arizona Free Enterprise Club's Freedom Club PAC versus Bennett, Burdick v. Takushi, Pike v. Bruce Church Incorporated. The Casey undue burden standard is the same. It also resembles general standards that courts work with daily and in other legal spheres, like the rule of reason in antitrust law, or the arbitrary and capricious standard for agency decision-making. Applying general standards to particular cases is, in many contexts, just what it means to do law, and the undue burden standard has given rise to no unusual difficulties. Of course, it has provoked some disagreement among judges. Casey knew it would. That much is to be expected in the application of any legal standard which must accommodate life's complexity. Which is to say that much is to be expected in the application of any legal standard, but the majority vastly overstates the divisions among judges applying the standard. We count essentially two. The Chief Justice disagreed, and the other justices in the June medical majority about whether Casey called for weighing the benefits of an abortion regulation against its burdens. We agree that the June medical difference is a difference, but not one that would actually make a difference in the result of most cases. It did not in June medical, and not one incapable of resolution were it ever to matter. As for lower courts, there is now a one-year-old one-to-one circuit split about how the undue burden standard applies to state laws that ban abortions for certain reasons, like fetal abnormality. That is about it, as far as we can see, and that is not much. This court mostly does not even grant certiorari on one-year-old one-to-one circuit splits, because we know that a bit of disagreement is an inevitable part of our legal system. To borrow an old saying that might apply here, not one or even a couple of swallows can make the majority's summer. Anyone concerned about workability should consider the majority's substitute standard. The majority says a law regulating or banning abortion must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. And the majority lists interests like respect for and preservation of prenatal life, protection of maternal health, elimination of certain medical procedures, mitigation of fetal pain, and others. This court will surely face critical questions about how that test applies. Must a state law must a state law allow abortions when necessary to protect a woman's life and health? And if so, exactly when? How much risk to a woman's life can a state force her to incur before the 14th Amendment's protection of life kicks in? Suppose a patient with pulmonary hypertension has a 30 to 50% risk of dying with ongoing pregnancy. Is that enough? And short of death, how much illness or injury can the state require her to accept? Consistent with the amendment's protection of liberty and equality. Further, the court may face questions about the application of abortion regulations to medical care most people view as quite different from abortion. What about morning after pill? What about the morning after pill? IUDs, in vitro fertilization, and how about the use of dilation and evacuation or methods for miscarriage management? Finally, the majority's ruling today invites a host of questions about the interstate conflicts. Can a state bar women from traveling to another state to obtain an abortion? Can a state prohibit advertising out-of-state abortions or helping women get to out-of-state providers? Can a state interfere with the mailings of drugs used for medication abortions? The Constitution protects travel and speech and interstate commerce, so today's ruling will give rise to a host of new constitutional questions. Far from removing the court from the abortion issue, the majority puts the court at the center of the coming interjurisdictional abortion wars. In short, the majority does not save judges from unwieldy tests or extricate them from the sphere of controversy. To the contrary, it discards a known, workable, and predictable standard in favor of something novel and probably far more complicated. It forces the court to wade further into hotly contested issues, including moral and philosophical ones, that the majority criticizes Roe and Casey for addressing. When overruling constitutional precedent, the court has almost always pointed to major legal or factual changes in undermining a decision's original basis. A review of the appendix to this dissent proves the point. Most successful proponents of overruling precedent, this court once said, have carried the heavy burden of persuading the court that changes in society or in the law dictate that the values served by stare decisis yield in favor of a greater objective. Certainly that was so of the main examples of the majority cites. Brown v. Board of Education and West Coast Hotel versus Parish. But it is not so today. Although nodding to some arguments others have made about modern developments, the majority does not really rely on them, no doubt seeing their slimness. The majority briefly invokes the current controversy over abortion, but it has to acknowledge that the same dispute has existed for decades. Conflict over abortion is not a change, but a constant. And as we will later discuss, the presence of that continuing division provides more of a reason to stick with than to jettison existing precedent. In the end, the majority throws long-standing precedent to the winds without showing that anything significant has changed to justify its radical reshaping of the law. Subsequent legal developments have only reinforced Roe and Casey. The court has continued to embrace all the decisions Roe and Casey cited, decisions which recognize a constitutional right for an individual to make her own choices about intimate relationships, the family, and contraception. Roe and Casey have themselves formed the legal foundation for subsequent decisions protecting these profoundly personal choices. As discussed earlier, the court relied on Casey to hold that the 14th Amendment protects same-sex intimate relationships. The court later invoked the same set of precedents to accord constitutional recognition to same-sex marriage. In sum, Roe and Casey are inextricably interwoven with decades of precedent about the meaning of the 14th Amendment. While the majority might wish it otherwise, Roe and Casey are the very opposite of obsolete constitutional thinking. Moreover, no subsequent factual developments have undermined Roe and Casey. When women continue to experience unplanned pregnancies and unexpected developments in pregnancies, pregnancies continue to have enormous physical, social, and economic consequences. Even an uncomplicated pregnancy imposes significant strain on the body, unavoidably involving significant psychological change and excruciating pain. For some women, pregnancy and childbirth can mean life-altering physical ailments or even death. Today, as noted earlier, the risks of carrying a pregnancy to term dwarf those of having an abortion. Experts estimate that a ban on abortions increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality, while black women face a 33% increase. Pregnancy and childbirth may also impose large-scale financial costs. The majority briefly refers to arguments about changes in laws relating to healthcare coverage, pregnancy discrimination, and family leave. Many women, however, still do not have adequate healthcare coverage before and after pregnancy, and even when insurance coverage is available, healthcare services may be far away. Women also continue to face pregnancy discrimination that interferes with their ability to earn a living. Paid family leave remains inaccessible to many who need it most. Only 20% of private sector workers have access to paid family leave, including a mere 8% of workers in the bottom quartile of wage earners. The majority briefly notes the growing prevalence of safe haven laws and demand for adoption. But to the degree that these are changes at all, they too are irrelevant. Neither reduces the health risks or financial costs of going through pregnancy and childbirth. Moreover, the choice to give up parental rights after giving birth is altogether different from the choice not to carry a pregnancy to term. The reality is that few women denied an abortion will choose adoption. The vast majority will continue, just as in Roe and Casey's time, to shoulder the cost of child rearing. Whether or not they choose to parent, they will experience the profound loss of autonomy and dignity that coerced pregnancy and birth always impose. Mississippi's own record illustrates how little facts on the ground have changed since Roe and Casey, notwithstanding the majority's supposed modern developments. 62% of pregnancies in Mississippi are unplanned, yet Mississippi does not require insurance to cover contraceptives and prohibits educators from demonstrating proper contraceptive use. The state neither bans pregnancy discrimination nor requires provision of paid parental leave. It has strict eligibility requirements for Medicaid and nutrition assistance, leaving many women and families without basic medical care or enough food. Although 86% of pregnancy-related deaths in the state are due to postpartum complications, Mississippi rejected federal funding to provide a year's worth of Medicaid coverage to women after giving birth. Perhaps unsurprisingly, health outcomes in Mississippi are abysmal for both women and children. Mississippi has the highest infant mortality rate in the country, and some of the highest rates for preterm birth, low birth weight, cesarean section, and maternal death. It is approximately 75 times more dangerous for a woman in the state to carry a pregnancy to term than to have an abortion. We do not say that every state is Mississippi, and we are sure some have made gains since Roe and Casey in providing support for women and children. But a state-by-state analysis by public health professionals shows that states with the most restrictive abortion policies also continue to invest the least in women's and children's health. The only notable change we can see since Roe and Casey cuts in favor of adhering to precedent. It is that American abortion law has become more and more aligned with other nations. The majority, like the Mississippi legislature, claims that the United States is an extreme outlier when it comes to abortion regulation. The global trend, however, has been toward increased provision of legal and safe abortion care. A number of countries, including New Zealand, the Netherlands, and Iceland, permit abortions up to a roughly similar time as Roe and Casey set. Canada has decriminalized abortion at any point in a pregnancy. Most Western European countries impose restrictions on abortion after 12 to 14 weeks, but they have often had liberal exceptions to those time limits, including to prevent harm to a woman's physical or mental health. They also typically make access to early abortion easier, for example, by helping cover its cost. Perhaps most notable, more than 50 countries around the world in Asia, Latin America, Africa, and Europe have expanded access to abortion in the last 25 years. In light of that worldwide liberalization of abortion laws, it is American states that will become international outliers after today. In sum, the majority can point to neither legal nor factual developments in support of its decision. Nothing that has happened in this country or the world in recent decades undermines the core insight of Roe and Casey. It continues to be true that, within the constraints those decisions established, a woman, not the government, should choose whether she will bear the burdens of pregnancy, childbirth, and parenting. In support of its holding, the majority invokes two watershed cases overruling prior constitutional precedents, West Coast Hotel Company versus Parish and Brown v. Board of Education. But those decisions, unlike today's, responded to changed law and to changed facts and attitudes that had taken hold throughout society. As Casey recognized, the two cases are relevant only to show by stark contrast how unjustified overturning the right to choose is. West Coast Hotel overruled Adkins Children's Hospital of D.C. and a whole line of cases beginning with Lochner v. New York. Adkins had found a state minimum wage law unconstitutional because, in the court's view, the law interfered with a constitutional right to contract. But then the Great Depression hit, bringing it with unparalleled economic despair. The experience undermined, in fact, it disproved Adkins' assumption that a wholly unregulated market could meet basic human needs. As Justice Jackson, before becoming a justice, wrote of that time, the older world of laissez-faire was recognized everywhere outside the court to be dead. In West Coast Hotel, the court caught up, recognizing through the lens of experience the flaws of existing legal doctrine. The havoc the Depression had worked on ordinary Americans, the court noted, was common knowledge through the length and breadth of the land. The laissez-faire approach had led to the exploiting of workers at wages so low as to be insufficient to meet the bare cost of living. And since Adkins was decided, the law has also changed. In several decisions, the court has started to recognize the power of states to implement economic policies designed to enhance their citizens' economic well-being. The statements in those decisions, West Coast Hotel explained, were impossible to reconcile with Adkins. There was no escaping the need for Adkins to go. Brown v. Board of Education overruled Plessy v. Ferguson, along with its doctrine of separate but equal. By 1954, decades of Jim Crow had made clear what Plessy's turn of phrase actually meant: inherent inequality. Segregation was not and could not ever be consistent with the Reconstruction Amendments ratified to give the former slaves full citizenship. Whatever might have been thought in Plessy's time, the Brown Court explained, both experience and modern authority showed the detrimental effects of state-sanctioned segregation. It affected children's hearts and minds in a way unlikely ever to be undone. By that point, too, the law had begun to reflect that understanding. In a series of decisions, the court had held unconstitutional public graduate schools' exclusion of black students. See, for example, Sweat v. Painter, Sipule v. Board of Regents of University of Oklahoma, Missouri ex rel. Gaines v. Canada. The logic of those cases, Brown held, applied with added force to children in grade and high schools. Changed facts and changed law required Plessy's end. The majority says that in recognizing those changes, we are implicitly supporting the half-century interlude between Plessy and Brown. That is not so. First, if the Brown court had used the majority's method of constitutional construction, it might not ever have overruled Plessy, whether 5 or 50 or 500 years later. Brown thought that whether the ratification-era history supported desegregation was at best inconclusive. But even setting that aside, we are not saying that a decision can never be overruled just because it is terribly wrong. Take West Virginia Board of Education versus Barnett, which the majority also relies on. That overruling took place just 3 years after the initial decision, before any notable reliance interests had developed. It happened as well because individual justices changed their minds, not because a new majority wanted to undo the decisions of their predecessors. Both Barnett and Brown, moreover, share another feature setting them apart from the court's ruling today. They protected individual rights with a strong basis in the Constitution's most fundamental commitments. They did not, as the majority does here, take away a right that individuals have held and relied on for 50 years. To take that action based on a new and bare majority's declaration that two courts got the result egregiously wrong. And to justify that action by reference to Barnett or to Brown, a case in which the Chief Justice also wrote an 11-page opinion in which the entire court could speak with one voice, these questions answer themselves. Casey itself addressed both West Coast Hotel and Brown, and found that neither supported Roe's overruling. In West Coast Hotel, Casey explained, the facts of economic life had proved different from those previously assumed. And even though Plessy was wrong the day it was decided, the passage of time had made that ever more clear to ever more citizens. Society's understanding of the facts in 1954 was fundamentally different than in 1896. So the court needed to reverse course. in constitutional adjudication as elsewhere in life, changed circumstances may impose new obligations. And because such dramatic change had occurred, the public could understand why the court was acting. The nation could accept each decision as a response to the court's constitutional duty. But that would not be true of a reversal of Roe, because neither the factual underpinnings of Roe's central holding nor our understanding of it has changed. That is just as much so today, because Roe and Casey continue to reflect, not diverge from, broad trends in American society. It is, of course, true that many Americans, including many women, opposed those decisions when it issued and do so now as well. Yet the fact remains, Roe and Casey were the product of a profound and ongoing change in women's roles in the latter part of the 20th century. Only a dozen years before Roe, the court described women as the center of home and family life, with special responsibilities that precluded their full legal status under the Constitution. By 1973, when the court decided Roe, fundamental social change was underway regarding the place of women, and the law had begun to follow. By 1992, when the court decided, Reed v. Reed, recognizing that the Equal Protection Clause prohibits sex-based discrimination. By 1992, when the court decided Casey, the traditional view of a woman's role as only a wife and mother was no longer consistent with our understanding of the family, the individual, or the Constitution. Under that charter, Casey understood women must take their place as full and equal citizens, and for that to happen, women must have control over their reproductive decisions. Nothing since Casey, no changed law, no changed fact, has undermined that promise. The reasons for retaining Roe and Casey gain further strength from the overwhelming reliance interests those decisions have created. The court adheres to precedent not just for institutional reasons, but because it recognizes that stability in the law is an essential thread in the mantle of protection that the law affords the individual. So an overruling precedent would dislodge individuals' settled rights and expectations. Stare decisis has added force, citing Justice Stevens. And then Casey understood that to deny individuals reliance on Roe was to refuse to face the facts. Today, the majority refuses to face the facts. The most striking feature of the majority is the absence of any serious discussion of how its ruling will affect women. By characterizing Casey's reliance arguments as generalized assertions about the national psyche, it reveals how little it knows or cares about women's lives or about the suffering its decision will cause. In Casey, the court observed that for 2 decades, individuals have organized intimate relationships and made significant life choices in reliance on the availability of abortion in the event that contraception should fail. Over another 30 years, that reliance has solidified. For half a century now, in Casey's words, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Indeed, all women now of childbearing age have grown up expecting that they would be able to avail themselves of Roe's and Casey's protections. The disruption of overturning Roe and Casey will therefore be profound. Abortion is a common medical procedure and a familiar experience in women's lives. About 18% of pregnancies in this country end in abortion, and about 1/4 of American women will have an abortion before the age of 45. Those numbers reflect the predictable and life-changing effects of carrying a pregnancy, giving birth, and becoming a parent. As Casey understood, people today rely on their ability to control and time pregnancy. As Casey understood, people today rely on their ability to control and time pregnancies when making countless life decisions: where to live, whether and how to invest in education or careers, how to allocate financial resources, and how to approach intimate and family relationships. Women may count on abortion access for when contraception fails. They may count on abortion access for when contraception cannot be used. For example, if they were raped. They may count on abortion for when something changes in the midst of a pregnancy, whether it involves family or financial circumstances, unanticipated medical complications, or heartbreaking fetal diagnosis. Taking away the right to abortion, as the majority does today, destroys all those individual plans and expectations. In doing so, it diminishes women's opportunities to participate fully and equally in the nation's political, social, and economic life. The majority's response to these obvious points exists far from the reality American women actually live. The majority proclaims that reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. The facts are 45% of pregnancies in the United States are unplanned. Even the most effective contraceptives fail, and effective contraceptives are not universally accessible. Not all sexual activity is consensual, and not all contraceptive choices are made by the party who risks pregnancy. The Mississippi law at issue here, for example, has no exception for rape or incest, even for underage women. Finally, the majority ignores, as explained above, that some women decide to have an abortion because their circumstances changed during a pregnancy. Human bodies care little for hopes and plans. Events can occur after conception, from unexpected medical risks to changes in family circumstances, which profoundly alter what it meant to carry a pregnancy to term. In all these situations, women have expected that they will get to decide, perhaps in consultation with their families or doctors, but free from state interference, whether to continue a pregnancy. For those who will now have to undergo that pregnancy, the loss of Roe and Casey could be disastrous. That is especially so for women without money. When we count the cost of Roe's repudiation on women who once relied on that decision, it is not hard to see where the greatest burden will fall. In states that bar abortion, women of means will still be able to travel to obtain the services they need. It is women who cannot afford to do so who will suffer most. These are the women most likely to seek abortion care in the first place. Women living below the federal poverty line experience unintended pregnancies at rates 5 times higher than higher income women do, and nearly half of women who seek abortion care live in households below the poverty line. Even with Roe's protection, these women face immense obstacles to raising the money needed to obtain abortion care early in their pregnancy. After today, in states where legal abortions are not available, they will lose any ability to obtain safe, legal abortion care. They will not have the money to make the trip necessary or to obtain childcare for that time, or to take time off work. Many will endure the costs and risks of pregnancy and giving birth against their wishes. Others will turn in desperation to illegal and unsafe abortions. They may lose not just their freedom, but their lives. Finally, the expectation of reproductive control is integral to many women's identity and their place in the nation. That expectation helps define a woman as an equal citizen with all the rights, privileges, and obligations that status entails. It reflects that she is an autonomous person and that society and the law recognize her as such. Like many constitutional rights, the right to choose situates a woman in relationship to others and to the government. It helps define a sphere of freedom in which a person who has the capacity to make choices free of government control. As Casey recognized, the right orders her thinking as well as her living. Beyond any individual choice about residence or education or career, her whole life reflects the control and authority that the right grants. Withdrawing a woman's right to choose whether to continue a pregnancy does not mean that no choice is being made. It means that a majority of today's court has wrenched this choice from women and given it to the states. It allows a state to exert control over one of the most intimate and personal choices a woman may make is not only to affect the course of her life, monumental as those effects might be. It is to alter her views of herself and her understanding of her place in society, as someone with the recognized dignity and authority to make these choices. Women have relied on Roe and Casey in this way for 50 years. Many have never known anything else. When Roe and Casey disappear, the loss of power, control, and dignity will be immense. The court's failure to perceive the whole swath of expectations Roe and Casey created reflects an impoverished view of reliance. According to the majority, a reliance interest must be very concrete, like those involving property or contract. While many of this court's cases addressing reliance have been in the commercial context, none holds that interests must be analogous to commercial ones to warrant stare decisis protection. This unprecedented assertion is, at bottom, a radical claim to power. By disclaiming any need to consider broad swaths of individuals' interests, the court arrogates to itself the authority to overrule established legal principles without even acknowledging the costs of its decisions for the individuals who live under the law. Costs that this court's stare decisis doctrine instructs us to privilege when deciding whether to change course. The majority claims that the reliance interests women have in Roe and Casey are too intangible for the court to consider, even if it were inclined to do so. This is to ignore as judges what we know as men and women. The interests women have in Roe and Casey are perfectly viscerally concrete. Countless women will now make different decisions about careers, education, relationships, and whether to try to become pregnant than they would have when Roe served as a backstop. Other women will carry pregnancies to term, with all the costs, risks, and risk of harm that involves when they would previously have chosen to obtain an abortion. For millions of women, Roe and Casey have been critical in giving them control of their bodies and their lives. Closing our eyes to the suffering today's decision will impose will not make that suffering disappear. The majority cannot escape its obligation to count the costs of its decision by invoking the conflicting arguments of contending sides. Stare decisis requires that the court calculates the costs of a decision's repudiation on those who have relied on the decision, not on those who have disavowed it. More broadly, the majority's approach to reliance cannot be reconciled with our nation's understanding of constitutional rights. The majority's insistence on a concrete economic showing would preclude a finding of reliance on a wide variety of decisions recognizing constitutional rights, such as the right to express opinions, or choose whom to marry, or decide how to educate children. The court, on the majority's logic, could transfer those choices to the state without having to consider a person's settled understanding that the law makes them hers. That must be wrong. All those rights, like the right to obtain an abortion, profoundly affect and indeed anchor individual lives. To recognize that people have relied on these rights is not to dabble in abstractions, but to acknowledge some of the most concrete and familiar aspects of human life and liberty. All those rights, like the one here, also have a societal dimension because of the role constitutional liberties play in our structure of government. See, for example, Dickerson, recognizing that Miranda warnings have become part of our national culture in declining to overrule Miranda versus Arizona. Rescinding an individual right in its entirety and conferring it on the state, an action the court takes today for the first time in history, affects all who have relied on our constitutional system of government and its structure of individual liberties protected from state oversight. Roe and Casey have, of course, aroused controversy and provoked disagreement, but the right those decisions conferred and reaffirmed is part of society's understanding of constitutional law and of how the court has defined the liberty and equality that women are entitled to claim. After today, young women will come of age with fewer rights than their mothers and grandmothers had. The majority accomplishes that result without so much as considering how women have relied on the right to choose or what it means to take that right away. The majority's refusal even to consider the life-altering consequences of reversing Roe and Casey is a stunning indictment of its decision. One last consideration counsels against the majority's ruling the very controversy surrounding Roe and Casey. The majority accuses Casey of acting outside the bounds of the law to quell the conflict over abortion, of imposing an unprincipled settlement of the issue in an effort to end national division. But that is not what Casey did. As shown above, Casey applied traditional principles of stare decisis, which the majority today ignores, in reaffirming Roe. Casey carefully assessed changed circumstances, none, and reliance interests, profound. It considered every aspect of how Roe's framework operated. It adhered to the laws in its analysis, and it reached the conclusion that the law required. True enough that Casey took notice of the national controversy about abortion. The court knew in 1992, as it did in 1973, that abortion was a divisive issue. But Casey's reason for acknowledging public conflict was the exact opposite of what the majority insinuates. Casey addressed the national controversy in order to emphasize how important it was, in that case of all cases, for the court to stick to the law. Would that today's majority had done likewise? Consider how the majority itself summarizes this aspect of Casey. The American people's belief in the rule of law would be shaken if they lost respect for this court as an institution that decides important cases based on principle, not social and political pressures. There is a special danger that the public will perceive a decision as having been made for unprincipled reasons when the court overrules a controversial watershed decision, such as Roe. A decision overruling Roe would be perceived as having been made under fire and as a surrender to political pressure. That seems to us a good description, and it seems to us right. The majority responds, if we understand it correctly, well, yes, but we have to apply the law. To which Casey would have said, that is exactly the point. Here, more than anywhere, the court needs to apply the law, particularly the law of stare decisis. Here we know that citizens will continue to contest the court's decision because men and women of good conscience deeply disagree about abortion. When that contestation takes place, but when there is no legal basis for reversing course, the court needs to be steadfast to stand its ground. That is what the rule of law requires, and that is what respect for this court depends on. The promise of constancy once given, in so charged an environment, Casey explained, binds its maker for as long as the understanding of the issue has not changed so fundamentally as to render the commitment obsolete. A breach of that promise is nothing less than a breach of faith, and no court that broke its faith with the people could sensibly expect credit for principle. No court breaking its faith in that way would deserve credit for principle. As one of Casey's authors wrote in another case, our legitimacy requires above all that we adhere to stare decisis in sensitive political context where partisan controversy abounds. Justice Jackson once called a decision he dissented from a loaded weapon ready to hand for improper use, citing Korematsu versus United States. We fear that today's decision departing from stare decisis for no legitimate reason is its own loaded weapon. Weakening stare decisis threatens to upend bedrock legal doctrines far beyond any single decision. Weakening stare decisis creates profound legal instability, and as Casey recognized, weakening stare decisis in a hotly contested case like this one calls into question this court's commitment to legal principle. It makes the court appear not restrained but aggressive, not modest but grasping. In all those ways, today's decision takes aim, we fear, at the rule of law. Power, not reason, is the new currency of this court's decision-making. Roe stood for 50 years. Casey, a precedent about precedent, specifically confirmed Roe, has stood for 30, and the doctrine of stare decisis, a critical element of the rule of law, stands foursquare behind their continued existence. The right those decisions established and preserved is embedded in our constitutional law, both originating in and leading to other rights protecting bodily integrity, personal autonomy, and family relationships. The abortion right is also embedded in the lives of women, shaping their expectations, influencing their choices about relationships and work, supporting, as all reproductive rights do, their social and economic equality. Since the right's recognition and affirmation, nothing has changed to support what the majority does today. Neither law nor facts nor attitudes have provided any new reasons to reach a different result than Roe and Casey did. All that has changed is this court. Mississippi and other states, too, knew exactly what they were doing in ginning up new legal challenges to Roe and Casey. The 15-week ban at issue here was enacted in 2018. Other states quickly followed. Between 2019 and 2021, 8 states banned abortion procedures after 6 to 8 weeks of pregnancy, and 3 states enacted all-out bans. Mississippi itself decided in 2019 that it had not gone far enough. The year after enacting the law under review, the state passed a 6-week restriction. A state senator who championed both Mississippi laws said the obvious out loud. A lot of people thought he explained that finally we have a conservative court, and so now would be a good time to start testing the limits of Roe. In its petition for certiorari, the state had exercised a smidgen of restraint. It had urged the court merely to roll back Roe and Casey, specifically assuring the court that the questions presented in its petition do not require the court to overturn those precedents. But as Mississippi grew ever more confident in its prospects, it resolved to go all in. It urged the court to overrule Roe and Casey. Nothing but everything would be enough. Earlier this term, this court signaled that Mississippi's stratagem would succeed. Texas was one of a fistful of states to have recently banned abortions after 6 weeks of pregnancy. It added to that flagrantly unconstitutional restriction an unprecedented scheme to evade judicial scrutiny. And 5 justices acceded to that cynical maneuver. They let Texas defy this court's constitutional rulings, nullifying Roe and Casey ahead of schedule in the nation's second largest state. And now the other shoe drops, courtesy of that same 5-person majority. We believe the Chief Justice's opinion is wrong too, but no one should think that there is not a large difference between upholding a 15-week ban on the grounds he does and allowing states to prohibit abortion from the time of conception. Now a new and bare majority of this court, acting at practically the first moment possible, overrules Roe and Casey. It converts a series of dissenting opinions expressly expressing antipathy towards Roe and Casey into a decision greenlighting even total abortion bans. It eliminates a 50-year-old constitutional right that safeguards women's freedom and equal station. It breaches a core rule of law principle designed to promote constancy in the law. In doing all of that, it places in jeopardy other rights, from contraception to same-sex intimacy and marriage. And finally, it undermines the court's legitimacy. Casey itself made the last point in explaining why it would not overrule Roe, though some members of its majority might not have joined Roe in the first instance. Just as we did here, Casey explained the importance of stare decisis, the inappositeness of West Coast Hotel and Brown, the absence of any changed circumstances or other reason justifying the reversal of precedent. The court, Casey explained, could not pretend that overruling Roe had any justification beyond a present doctrinal disposition to come out differently from the court of 1973, and to overrule for that reason. Quoting Justice Stewart, Casey explained that to do so, to reverse prior law upon a ground no firmer than a change in the court's membership, would invite the view that this institution is little different from the 2 political branches of the government. No view, Casey thought, could do more lasting injury to this court than to the system of law which it is our abiding mission to serve. For overruling Roe, Casey concluded the court would pay a terrible price. The justices who wrote those words, O'Connor, Kennedy, and Souter, they were judges of wisdom. They would not have won any contests for the kind of ideological purity some court watchers want justices to deliver. But if there were awards for justices who left this court better than they found it, and who for that reason left this country better, and the rule of law stronger, signed those justices up. They knew that the legitimacy of the court is earned over time. They also would have recognized that it can be destroyed much more quickly. They worked hard to avert that outcome in Casey. The American public, they thought, should never conclude that its constitutional protections hung by a thread, that a new majority adhering to a new doctrinal school could, by dint of numbers alone, expunge their rights. It is hard, no, it is impossible, to conclude that anything else has happened here. One of us once said that it is not often in the law that so few have so quickly changed so much. For all of us, in our time on this court, that has never been more true than today. In overruling Roe and Casey, this court betrays its guiding principles. With sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent. And then here's the appendix that I'm not really going to go through, but that was a good read. So, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and we'd be happy to take a look. Thank you.